Hello, NABU students. Once again, we're heading into topic number 7, forms of business organization, and we are going to be looking at sole proprietorships, partnerships, and then corporations. Sole proprietorships and partnerships carry a great deal of liability, personal liability for the owners of the business, and then we're going to look at corporations, which can be used to shift risk. They shift the risk from the owners to the corporation itself, providing, of course, that those involved in the corporation do their due diligence. So on slide 65, we list the 3 forms of business organization, and then in the next slide, we get into the actual discussion of those. A sole proprietorship is a business solely owned by one person. Now, generally they are small, however, they don't have to be. For example, before the Mars bar business was purchased by one of the big corporations in the United States, it was owned by a single individual, and yet it was a very huge operation. The difficulty with a sole proprietorship is that the sole proprietor has unlimited liability. The courts take no distinction between the business assets and the assets of the person involved. So, for example, if you had a business and you suffered a loss of $800,000 and your business was only worth $50,000, obviously there is a problem that the business assets cannot pay the debts. So the courts will then say, okay, Mr. Sole Proprietorship, you own a house, you own a cottage, you have 3 cars, you have some shares in Starbucks, and you have a sailboat. All those assets which are owned personally should be used to satisfy the debts of the business. Huge liability. You can, under certain circumstances, use a statute in British Columbia called the Family Law Act to reduce this liability a bit. But this isn't consistent across North America. So we have it here, we have it in Ontario. I don't know about the other provinces, and I have no idea about the states and no idea about Mexico. However, as far as British Columbia is concerned, you can, under certain circumstances, and do it very carefully with the help of a solicitor, transfer your assets that you own to your spouse. And then, of course, what happens is the business suffers this huge loss. They come and they go after not only the business assets, but then they say, okay, Mr. Sole Proprietorship, what do you own personally? And you go, I own nothing. Okay, and you're living in a nice house, you go to a nice cottage, you drive a nice car, you go sailing on the weekends, but it's all your spouse's assets, and those are beyond attachment by the creditors of the business. You have to do this transfer of assets for an estate planning purpose, okay? And it has to be done well in advance of any potential liability. So if I was in the office one day and I opened a file and I went, I made a mistake there. Oh, huge liability. And I called my wife and I said, guess what, dear? From now on, you own everything. Too late. We have a statute called the Fraudulent Conveyances Act, which says I would be conveying my assets to put them out of the reach of the creditor. However, if you do it well in advance, and if a long period of time goes by before there is liability, then the Fraudulent Conveyances Act does not apply, and you've made yourself judgment proof. Okay, judgment proof. There's a phrase or a term you should know. Judgment proof means that you have no assets that the claimant can go after. Now, judgment proof goes along with dry judgment. You get sued, your sole proprietorship fails, they look for assets that you have, and you have none, then obviously that judgment is going to turn out to be a dry judgment, which means there's no assets to cover it. So that's sole proprietorships, unlimited liability. The advantage, of course, of the sole proprietorship is that it's easy to set up. You get a business license, you register your name with the provincial government, and you lease premises, and bingo, you start operating. But with that goes this unlimited liability. So let's look then at partnerships. Partnerships are defined in the Partnership Act of British Columbia, and every jurisdiction has one of those. And it says that it's two or more persons working together with a common view to making a profit. There are numerous types of partnerships. There's the kind of partnerships that lawyers generally go into, like Mackay, Turlock, and Holden, where you're all general partners and you are jointly liable for the debts of the business, and you are jointly and severally liable for any other liabilities, such as tortious liability. So you have unlimited liability as a sole proprietor. What is worse in a partnership is that you're not only jointly liable, but you may wind up being liable for another partner's negligence. Okay, that's section 12, which is on screen 87. Is it 87 or 67? 67, sorry. And that particular provision, it makes a partnership even worse than a sole proprietorship in that regard. You have another, in a sole proprietorship, if I make a mistake, I won't like it, but at least it's my mistake, and I'm responsible to compensate people for it. In a partnership, one of the other partners makes a mistake, and gosh, I'm responsible for his or her mistake. So this joint liability and joint and several liability is very, very dangerous. The one way that you can eliminate that to a certain degree is to use the concept of the limited liability partnership, which is just a hybrid of a regular partnership. And what that means is that if there were three lawyers, I can put a barrier between me and the other lawyers. So if they're negligent, they are solely responsible for that. Okay. And that sounds good. And most law firms do that because it does reduce your risk. But you should realize that that doesn't reduce all the risk of being jointly and severally liable. Russell and Dumoulin was a huge law firm. It had many partners, and it had a huge number of associates. Well, the partners use a limited liability protection to protect themselves against one another, but they cannot protect themselves against the liability of an associate. So an associate makes a mistake, and there's a huge liability to the firm. All the partners are still jointly and severally liable for that mistake. Okay. But that does help a bit. So there's general partnerships, there's limited liability partnerships, and then in between there on number 2 on the screen is what's called limited partnerships. Let's say 3 of you go into partnership and you all put in all the money you have, and you borrow from the bank to the limit possible, and the partnership is doing well. So you want to take it to the next level, and you need an infusion of capital. The difficulty is you have no assets to pledge as security, so you cannot raise any money from the banks or angels, and you've run up your liability in the partnership. You can only get so much money from the bank for your accounts receivable, so you're sort of stymied. And then they think, hey, wait, my Uncle Harold sold a marketing and advertising law firm, and he has lots of money, and he may be willing to invest. Well, he's willing to invest in the partnership, but he does not want to become a partner because of the joint and several liability. So you can structure the partnership as a limited liability. It's a limited partnership. You register it in Victoria, British Columbia, or some other government registry across the country where you're operating. And you list the general partners and you list the limited partners. And it's called Mackay, Turlock, Holden Limited Partnership. And that means that somebody has invested but is not responsible. So Uncle Harold invests $50,000 in our partnership, and we think, oh, okay, great. Now we've got the investment we need. We can take it to the next level. And then suddenly we look at each other and we say, well, wait a minute, we got a problem. We really need a marketing and advertising plan to drive this. And we go, well, I do family law. Well, I do criminal law. Well, I do corporate commercial law. None of us know anything about marketing. Well, wait a minute, Uncle Harold. He sold his marketing and advertising firm, so let's get him to do a marketing plan for us. The danger for Uncle Harold is that right now he is a limited partner, which means he can only lose the $50,000 that he has invested in the partnership if there is a disaster and the business goes under. The partners, the general partners, are jointly and severally liable and jointly liable. Uncle Harold isn't until he does that marketing plan. Because in the Partnership Act, you form a limited partnership under Section 50, but Section 64 says if a limited partner gets involved in the management of the partnership, then he or she loses their limited liability protection. That's BC. There's a lot of other jurisdictions. You have to look at everyone specifically to determine whether they have this potential pitfall. Ontario, for example, has a similar section. The difference there, though, is they say if the limited partner is involved in control. What do they mean by that? Well, it doesn't mean you have complete control. You're the managing partner, or the senior partner. No. All it means is you are one of the partners that gets together and makes strategic decisions for the partnership. So you can even be a limited partner and be employed as an associate or as the office manager or whatever, and you will not lose your limited liability protection unless you get into a position where you can start to make strategic management decisions. Okay, so we've looked at sole proprietorships, we've looked at general partnerships, we've looked at limited partnerships, and we've looked at limited liability partnerships. Interesting to note again that limited liability partnerships are different. Every jurisdiction in the United States and Canada has this section in their statute, and I don't know about Mexico, but it's not important for the course material. Well, the difference is BC was the last jurisdiction to do this, and so what we did was we took one step further than the others. The others say that limited liability partnerships are only available for professional operations. So they're available for lawyers, doctors, engineers, accountants, dentists, and architects. In BC, we were allowed to establish them for any type of business. So I had a marketing and advertising firm that had all sorts of really interesting corporations, and boy, this comes out and they want to have a limited liability partnership for their next venture. And I talked to the senior owner and I said, well, why? And he said, well, because it sounds cool. And it protects us against, liability. And I said, Sonny, it's inappropriate because you can incorporate a company and have limited liability protection far beyond what is provided by an LLP. And he said, I don't understand. And so I said, well, so you have these partners that are protected one against the other. But your operation that you're trying to design is going to have a number of partners and then a whole group of workers. And it comes back to the fact that if a group, one of the workers makes a negligent mistake, then the partners are isolated from liability from one another, but they're not isolated from that liability. You're all jointly and severally liable for the mistakes of your employees. It's called vicarious liability. And we'll get into that when we talk about torts. So you have this available partnership structure, and it has a pitfall of liability, even perhaps worse than the sole proprietorship. The better way to do it, if it fits with your business plan, is to form a corporation. And we are going to look at, I've jumped to one slide. Slide 68 talks about risk management practices in corporations, or in our partnerships. And the thing to remember here is, if you have a partnership, you should have a partnership agreement. Eventually, when we talk about corporations, I am going to say if you have a corporation, you should have a shareholders agreement. Back to partnerships, why? Well, because that is a written document by which you can change the application of the Partnership Act to fit your needs. And it also means that you now have a better understanding one with the other about what the goals are, what each person's responsibilities are, and you can do some planning in there. I had one client who actually owned a marketing and advertising firm, and he sold the business and wanted to go into cruise ship franchising. So he found somebody else that wanted to go in with him, and they talked to their accountant, and the accountant says, okay, initially, because there is very little potential personal liability, form a partnership. And because then all the expenses leading up to the start of the business become expenses which can be deducted from income. Not so with a corporation, and we'll get into that later. So anyway, they decide they're going to do that, and they're going to be a franchise from a franchisor that has numerous places around the country doing cruise ship sales. And so they came to me and they said, okay, what do we need? And I said, you need a partnership agreement. So we registered the partnership and we got the business license and things like that. But I said, you need a partnership agreement. And they said, okay, sir, why? And I said, well, from what you've told me is that you plan to operate 7 days a week from 9 to 5. And any work done during the day becomes partnership revenue and is divided up accordingly. But you both acknowledge that if you, so one of you is going to work from Monday to Friday, and then the other one's going to work from Wednesday to Sunday. But you both acknowledge that if you decide to use the premises and the equipment and the contacts and everything after hours to do personal work in the cruise ship industry, then you get to keep that revenue yourself. And we should have a partnership agreement to do that. So they said, okay. And so I prepared the partnership agreement and sent it down to them. Well, they are busy working with the franchisor about the franchise agreement, and they're going on fam tours, which means they go on cruise ships and look at the facilities, and they're finding premises, dealing with the landlord, dealing with the leasehold improvements, getting equipment in there, hiring staff, learning the process of the franchise. Far too busy to worry about a partnership agreement. And I kept saying, sign the partnership agreement, review, sign the partnership agreement. And they keep saying, yeah, later. Well, they never got around to signing it. Bingo, they're operating. Well, when they're first operating, they're really busy. So they just have no time, so they don't sign it. Eventually, what happened was a Holland America cruise ship coming down from Alaska dings its propeller. And it's going to have downtime in Vancouver for 2 days to replace the propeller. Well, they have a 7-day cruise booked. If they lose 2 days, they have to give everybody back their money. And the ship is going to sit in Vancouver idle for 5 days before the next cruise starts. So it's a big loss for the cruise ship company. My client, my client in the partnership came to me and said, I want to hire that cruise ship for a trip to Alaska and back. We'll skip the ports up there, but I want to do that. And he said, I'm working with an association which wants to do something really interesting for its 50th anniversary annual general meeting. And so he went to them and he said, look, how would you like to have a 5-day cruise to Alaska and back for your big event? And they said that was fantastic. So he contacts Holland America, and I got to work on the charter agreement, because that's how you charter the ship for a cruise. But he's doing this after hours, right? And so anyway, I should back up. The cruise ship has 1,200 passengers. It was when they were smaller. Now they're sort of like a floating city. But it was 1,200 people. And he goes to the association and he sells 900 suites, or rooms, just like that, right? And he comes walking into the office and he's saying, I'm in the money, I'm in the money. And his partner says, what's going on? He explains. And his partner says, oh, great. You're like, how much are we making? And he said, no. I'm doing this after hours. So it's how much am I making? And she said, no, I don't think so, because that's a partnership operation, so the revenue should come into the partnership. And he said, no, we've got this agreement. We got this partnership agreement whereby, if we do something after hours, we get to keep the money individually. And she goes, I don't remember that we ever signed that. So bingo, he's on the phone to me and he says, Peter, we've got this verbal agreement. Remember, verbal agreements are binding, aren't they? Well, generally they are, unless there's a statute that comes into play. And the Partnership Act applies to partnerships. And the only way that you can contract out from under some of the provisions of the partnership is to have a written agreement. Okay? And so he realized that he should have signed the partnership agreement, had not done so, and so he had to split the revenue with his partner. So he forced her then to sign the other 299 rooms. Wait, let's do the math. He sells 900, there's 1,200 on the boat, so that's 300 rooms that she should sell. No, she only had to sell 299 because the last room was a suite, which my client's lawyer, me, got because I took that as in lieu of legal fees for doing the work. I declared it. Okay, there is value there, so I declared it, put it on my taxes. Didn't make a big difference, but if I didn't, the Canada Revenue Agency would probably get a little upset about it. Anyway, so we have the situation where if you're having a partnership, you should have a partnership agreement, and you get it signed before you enter into the partnership. And the reason for that is when you're setting up the partnership, it's like being in love, and getting married. Da, 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 da. You're going down the aisle, and then after you're married, sometimes it doesn't work out, and so that's when you're going to split up the assets. That's when you're going to be fighting, and the lawyers are going to be fighting, and you'll split up the assets, and both lawyers will get big legal fees. So you get a prenuptial agreement when you're getting married, and that talks about how you split up the assets if it doesn't work out. The problem is everybody that gets married thinks it's going to last forever, and this is wonderful, and this is my soulmate, and things happen. Same thing with partnerships. You're going into a partnership, this is wonderful, we're all going to make a fortune, and then when you're struggling, that's not the time to start worrying about these other matters. Okay, so that's partnerships. In this partnership agreement, you should have a number of specific clauses. One is life insurance on the key partners and disability insurance. I'm going to make this simple. It should apply to most relationships, but because you're key people in this operation, let's say this is an adventure tourism business where you are both guides and you take groups of corporate executives into the wilderness and you do this survival thing to build up team spirit and stuff that corporations just love. Anyway, so it's really important for both of you to be working. And your partner becomes disabled. Well, under employment law, there's this requirement, particularly in the province of BC and other Canadian provinces, that you have to accommodate. Okay, you cannot say, oh, your disability interferes with your ability to do the job on an ongoing basis, so goodbye, you're gone. Particularly because in a partnership, you cannot just, goodbye, you're gone to a partner. So you have this problem that here's this person that, oh gosh, we'll have them man the office and, I'll take the groups out in the force. Well, suddenly you're getting half the work, but you're still splitting the profit, which is not particularly fair. And so in this situation, you might want to have disability insurance, which will then bring money into the partnership to give to the disabled partner. And you say, really sorry what happened, but here, go off with this money and see if you can do something that's productive and satisfying with the remainder of your life. It sounds brutal, but you have to do that, okay? And then, of course, the other aspect is that you could wind up with a situation where the partner dies. And, you both put in $100,000 and you're 50-50 partners, but oh, wait, now your partner dies. Yay, I'm sad that my partner died, but whoa, I now am the sole proprietorship of a $200,000 business. No, you're not, because the estate of the deceased partner is going to come and say, half that is mine, please pay it to me. And you're not going to have the money to pay it to them. You'll probably have to sell the partnership or the business comes to an end. If you have key person life insurance, then that brings money into the partnership, which you can then pay off the estate with. And so you have partnership interest sale on death, which means the partnership's interest has to be sold. Okay, and so you got the money to buy it. Key person insurance provides the money, and then you have an annulment clause. Why would you have that? Well, the important thing in here is that you want the agreement between you and your partner to also apply to your estates. Well, they're not privy to the contract. And there's a term you should know, privity of contract. It means only the parties to the contract are bound by its terms, okay? So how do you bind your representative of your estate? Well, you put in this inurement clause, which says this contract and the provisions herein shall inure to the benefit of and be binding upon the parties hereto, their heirs, if they don't have wills, their beneficiaries, if they do, their representatives and assigns. Okay. Then it applies to the estate. Now, the estate's probably going to say, no, we don't agree with that. And they'll sue. Well, you don't want that. So you put in a clause in there that says any dispute with respect to the partnership agreement should go to mediation and arbitration and stay out of the courts. Okay, so that's partnerships. And let's see, how long have I been going? 29 minutes. Okay, I should keep going. The next slide is we go into corporations. And a corporation is a juridical person. What does that mean? Well, it is a creature of statute. I'm a natural person, you're a natural person. But what the law does is it makes the corporation like a natural person. So Section 30 of the BC Business Corporation Act, and every jurisdiction on North America, including Mexico, has this. And it says a corporation has all the powers and capacity of a natural person of full capacity. Wow, okay, so now you have this separate legal entity, and this becomes a very, very convenient and easy to use method of shifting the risk in the operation from the owners to the corporate entity. The corporation enters into contracts with suppliers, with customers, and the suppliers and customers can only sue the corporation if you do your due diligence. And we'll come back to that later. So they can only sue the corporation, again, because of privity of contract. And this becomes a way of isolating yourself from liability. You own shares in it. Ooh, well, okay. So you're liable as a shareholder. No, you're not. Section 30 says it's a separate legal entity. Section 87 of the statute says that the shareholders are not liable for the debts and obligations of the corporation, other than they lose the investment that they've made for their shares. Let's do some terminology. We got corporation and company. This becomes extremely awkward because in civil law countries like Mexico, they use the term company pretty much to mean any business organization. Canada and the United States, this can be done, but the general rule is that you use corporation to denote an incorporated entity, and you use company simultaneously. And then you just refer to sole proprietorships as sole proprietorships and partnerships as partnerships. In the European continent, you have no idea. Yes, there's a company and it's a partnership. It's a company and it's a sole proprietorship. In North America, United States, and Canada, you may look at something like the Hudson's Bay Company, big, right? But it doesn't end in Ltd. Anchor Corp. So, is it a corporation? Well, yes, it is. But that's because it was incorporated so long ago that they didn't have a Company Act which said you can have a private corporation, and if you do, it ends in Inc., Ltd., or Corp. So consequently, they could use any name they wanted. And when the Hudson's Bay started, it was a United Kingdom company, and it was designed to do the fur trade in Canada. And so they called it the Company of Adventurers and Explorers. Well, how do they incorporate the company if there's no statute that makes it a separate legal entity? These are high rollers, okay? So they go in to see the king. Your Highness, I would like to be formed into a corporation. What do you want to be called? I want to be called the Company of Adventurers and Explorers. Well, why do you want to do this? Well, because the only forms of business organization right now are sole proprietorships and partnerships. This cannot be a sole proprietorship because I do not have enough money to do it myself. This cannot be a partnership because I am going to need thousands and thousands of partners, and that would be total chaos. Okay? And so I want to form a new type of business, and I want to have members that own the business, and then I want a board of directors that run it. Okay? And the king said, okay, so you want to be called the Company of Adventurers Explorer? Yes, thou art one. Okay, and the company is formed. That was in 1640. Well, one of the advantages of corporations is that they continue in existence, right? And yeah, the Hudson's Bay Company is still in existence today. And it wasn't until about 1979-80 when they stopped doing what they were originally designed to. They were doing the fur trade. So then they became department stores and got involved in other ventures. But the department stores sold furs. So, the big environmental, you're killing animals, don't wear furs. And so they ceased to sell real fur about 1980. But they still exist, all right? So they go on forever, these companies. Bet you $20 that not one of the original natural shareholders is alive today. Okay, in 1640, some people became members which are synonymous with shareholders. We'll get into that in a minute. And when they passed away, their shares were passed to their heirs or beneficiaries. When they died, passed. When they died, passed. And so none of those are alive today, but the corporation can exist indefinitely. So how do you know? Well, there was a business in Richmond called I'll make up a name, ABC Manufacturing Company. And my client was going to deal with them. And they said, am I dealing with a corporation or not? And I said, I don't know, but I'll find out. And I did a search at the registry in Victoria. And no, it was a sole proprietorship. And it was just Fred Smith doing business as ABC Manufacturing Company. So there's no law prohibiting the use of the word company, but there's a general rule that if you're a corporation, you're a company, and then if you're not, you're just a business. Okay, that's corporation and company. Private corporation, public corporation. Private corporations is what most people use when they just want to start a business, but they want the limited liability protection that a corporation provides. And they're relatively easy to set up, and they're fairly small. Two things: you have to have less than 49 shareholders. Most of them have 1 to 10 probably. And then your shares must in some way be restricted to the share sales. Okay, so how's that done? Well, you form a corporation and you have articles of incorporation, and you can use the standard ones that the Register of Companies provides, or you can make up your own. And then one of the last lines says, the sales of shares are restricted, and to do so you must require the consent of the directors. Okay, so I cannot, in a private corporation, just sell my shares. Even if I find somebody willing to buy them, which is difficult quite often, but I cannot sell. I have to go to the directors and say, may I sell my shares? And they go, yes or no. Okay, and we'll come back to that because my client that had the problem with the partnership ran afoul of that one too. That's a private corporation. A public corporation, shares are traded on the stock exchange. Okay, and the difference between the two is the regulatory requirement and the cost of forming a private corporation is relatively low. To get listed on the stock exchange is prohibitively expensive for most people. All right, so we are going to get into, let's see, what's the shareholder versus member. And I think we're going to take a short break, and then we'll come back for that. I am in desperate need of it. Okay, continuing along, we're talking about the difference between member and shareholder, and really the only distinction is the statute that you're incorporating under. Back when the Hudson's Bay Company was formed as the Company of Adventurers and Explorers, they hadn't thought about shares and stock exchanges and initial public offerings and things like that. And so the person that was talking to the king said, I want these members, okay? And so members became synonymous with owning shares in the company. They created the Company Act in the mid-1800s in England, and it was adopted almost in identical form in Canada. It referred to members, okay? And it wasn't until 2003 in the province of British Columbia that we modernized our Company Act and called it the BC Business Corporations Act. And under that, we referred to the people that own shares as shareholders. Okay, so that explains that distinction. Now, the distinction between shares and stock is totally irrelevant. Again, it's just the size of the North American area. In Canada, we call them shares. In the United States, we call them stock. You hold stock in a company, or you own shares. It's synonymous, so no big deal. Now, the last distinction is between the federal jurisdiction and the provincial jurisdictions here, and in the United States, the federal jurisdiction and the state jurisdictions. We have a federal Business Corporations Act under which you would incorporate companies federally. Insurance companies other than car insurance, airlines, railways, companies like that. And banks, under the Bank Act. But provincially, you can form a corporation except to do those kinds of work. I think the term ultra vires I used earlier on in one of my lectures when I was talking about constitutional challenge between governments. Well, the same thing about corporation. If I incorporated a company in British Columbia to run a bank, and I wanted to call it the Really Solid Bank of Lower Lonsdale, which doesn't sound very solid, does it? And I start taking deposits and start paying interest and giving out checks and things. I will be stopped from doing that because I incorporated under the wrong jurisdiction. I have to incorporate federally under the Bank Act, and there's all sorts of restrictions which would make it almost impossible for the average citizen to do it. Years ago, I had two students in my business law class that came up to me and they said that they and their fathers were going to form a corporation which was going to start a franchise restaurant operation, which was going to be the next McDonald's. And they were going to call it Tons of Tofu. No, I'm only kidding. I cannot tell you the name because I don't even know whether they've started doing it or not. Because I didn't do very much legal work for them. But they asked me if I would review their incorporation documents. And I said, well, sure. And they showed me, and they were incorporating federally. And I said, why? And they said, well, because we want to operate all across Canada. And I said, but that doesn't help you, because if you incorporate federally, you have to turn around and extraprovincially incorporate in British Columbia, which means you have 2 incorporation fees. And they went, oh, darn, that means we'd have to extraprovincially incorporate in all 10 provinces. And I said, why? And they said, because, we're going to have franchises there. I said, no, think it through. You do not incorporate federally. You incorporate in British Columbia. You have your head office there. Then you want a franchisee in Saskatchewan. Well, they incorporate in Saskatchewan, and your corporation, the franchisor, will have a franchise agreement with that franchisee. But you don't have to be doing business in Manitoba in order to do that. That's just a contract. So you have to look at the relevant jurisdictions and decide what's best for you. My client up north that has the lodge and on the property there's a hangar and he has a couple of planes. Well, he has 2 corporations. He has the incorporation which runs the lodge operation, and that's incorporated in the province of British Columbia. And then he has the airline that, it's a small one. He had 3 planes at one point. Now he just has 2, but he had to incorporate that federally. All right. Okay, so that explains that. Now the next slide, slide 21, is the most important one that you're going to have to know for this class. It explains the advantages of a corporation, and I should have put in the other advantages as well. And so I'm probably going to add a slide, slide 71, and I'm just going to do that right now. New slide. Okay, and I will put that so that you have it available. The corporation is, as I said, a separate legal entity, and the biggest advantage that it provides is that you have this limited liability protection. And we're going to concentrate on private corporations, but this would apply to public corporations as well. So on that slide, you see this blue globe, and it says corporation. And then you see lines down to S's. Well, those are the shareholders. Okay? The shareholders elect the directors, and then the directors appoint the officers. So this corporation, because it's a separate legal entity as specified by Section 70, which is on that slide, and the shareholders are not responsible for the debts and obligations of the corporation, and that's Section 87 on that slide. So we have this protection between the shareholders and the corporation. And one of the very first cases that really decided whether or not this function of limited liability was valid was the Solomon versus Solomon case in the United Kingdom. It's the landmark case and it's still referenced today. The judge said that there's this veil, this imaginary barrier between the shareholders and the corporation, and he called it the corporate veil. And he said creditors and customers and everything cannot pierce the corporate veil to go after the shareholders. Well, that's great. The whole point of that was to encourage you to invest in business, to expand the economy. So you could invest in the company, and you knew that if the corporation went insolvent and you had invested $3,000, you would lose your $3,000, but no more. Okay? Well, that's great for big companies getting investments and growing the economy that way. But for a private corporation like you and I might have, and we are the shareholders, and we are the directors, and we are the officers, if we as shareholders were protected, but we were not protected as directors and officers, then the corporation would be of no help to us. So obviously this corporate veil continues up and is between the corporation and the officers and directors. But how does it do it? Because the BC Business Corporation Act does not have a section in there that says directors are not responsible, members or officers are not responsible. Well, it's common law, okay? It's the law of contract, really, that provides this additional protection. And this is called agency law, all right? So I'm going to skip over my new slide 72, and I'm going to go to slide 73, which talks about agency. Okay, agency is a relationship where a principal authorizes through a contract with the agent to have the agent bring the principal into contracts with third parties. Let's go back and explain that, eh? I'll use an example. There was a young fellow who went through the international business program at Capilano University, came out the other side, came into my office, put a coffee and a donut in my desk, and he said, "Peter," and he leaned back and he said, "I want to get into international business. I have no money and I have student debts. How can I do this?" And I said, "Well, Vincent, it's really quite easy. You can afford to make business cards, right?" And he says, "Oh, yeah." I said, "Then get business cards, put your name on there, and underneath your name, put agent. And then schmooze at board of directors, board of trade meetings, chamber of commerce meetings, seminars that are being put on in the city, and hand out your business cards." So he did that. And lo and behold, he got a client. And now I have to tell you a little anecdote about that. There was a nurse in the interior of BC that worked with Alzheimer's patients. Now, Alzheimer's is horrible. Because what happens is, if you're suffering Alzheimer's, all of a sudden, you don't know who you are, you don't know where you are, and you don't know what you're doing. And Alzheimer's, as it progresses and gets worse and worse and worse and worse, eventually your brain forgets to tell you to breathe and you die. But earlier on, a lot of people die not because of that, but because they have a heart attack because of the stress of suddenly having no idea who you are. I mean, it must be horrible, absolutely horrible. Anyway, she sort of looked at the Alzheimer's patients that were having these episodes, and she thought, it's a lot like being a baby, Have a look at You're sitting there, you don't know who you are, you don't know where you are, and you don't know why, okay? And what happens when a baby cries? You give them a stuffy, and they go, "Oh," okay? So she thought, okay, I'm going to try that. So every time an Alzheimer's patient had an episode, she would reduce their stress by giving them a stuffy. Nurses and doctors all around the province started saying, "Hey, send us some of your stuffies," which was really kind of odd because I thought, wouldn't any stuffy do? Anyway, she suddenly realized she had a business opportunity. She could make these stuffies. And it was a bit more to it than that. They had the name and address and contact information for the person and other medical stuff so that if they wandered off, they could, whoever helped them would have this information. So anyway, she knew she had a business opportunity, and then she discovered in the province of British Columbia that the wages are so high in manufacturing that there was no way she could make these stuffies and then sell them because, who's going to buy a stuffy for $100 when you can go to the store and buy a stuffy for, a couple of bucks. So she figured out that she could make them less expensively in the Far East. Her problem was that she thought, wait a minute, to get to the Far East, you go west. Okay, I'm being a little facetious. What I mean is she did not know how to go to China to have dolls made. So she managed somehow to get one of Vincent's cards, and she called him up and she said, will you be my agent? Okay, so she becomes the principal. She authorizes Vince to become her agent, pays him commissions and costs. So he gets his expenses paid, plus he gets like $1 a doll or something. And she says, go to Hong Kong and enter me into a contract with a third party, i.e. the manufacturer, and you have my permission to do so. So then Vince comes into my office and he gives me a coffee and he gives me a donut. And he says, okay, Peter, now I'm an agent and I'm supposed to go to Hong Kong and do this. Like, how do I do this? And I said, okay, Vince, this is as easy as becoming an agent. I said, get on a plane. She's paying for it. Fly to Hong Kong. Get out of the plane. Get into a cab. She's paying for it. Say to the driver, take me to the Canadian consulate. Okay. They all speak English. They know where it is. They drive you there. You walk in. You talk to a Canadian trade officer and you go, hi, see this doll? I would like to find a manufacturer that makes those, please. That trade officer will take you out and introduce you to a couple of manufacturers, and you can make your choice as to which one you want. That's what he did. I get a call. He's in a bar in his hotel, and he says, I'm schmoozing here with people, handing out my business card, and he says, my expenses are all paid by my principal, and I'm an international agent. Okay, long story to explain that agency provides limited liability protection. How? Well, let's say the dolls get shipped from the manufacturer to the principal and the nurse doesn't pay. Who can the manufacturer sue? Well, if you look at the diagram, there's no line between the manufacturer and the agent. The contract is between the principal and the agent, so the manufacturer can only sue the principal because he's a third party to the contract between the principal and the agent, which means no privity of contract. Okay, no privity of contract, cannot sue the agent. Wow, perfect. Well, let's say the dolls are shipped and she pays, but the dolls turn out to be poorly manufactured. Who does she sue? Well, she can sue the agent. Why? The contract for the production of the dolls is between the nurse and the manufacturer. Privity of contract prevents Vince, as long as he's done his due diligence and found a decent manufacturer, and then there was just some problem with materials or something. Okay, so because you don't want to have him negligent. Okay, so as long as Vince does not hold himself out as the principal, which would be a breach of warranty of authority, as long as he makes it clear, I'm acting on her behalf, here's my letter of authority, he has no liability. The next slide, the same slide, puts it into a corporation type scenario. The principal is the corporation. The agent is the president. Okay, the president of the company working brings the corporation into contracts with suppliers, contracts with customers, and something happens, and the customer or the supplier wants to sue. Well, they cannot sue the president of the company. They can only sue the corporation. Okay, so if that particular problem brought the corporation to an end, the third party may be in a situation where they wind up with a dry judgment or only a limited amount of recovery, but they cannot go after the agent. So how do you make sure that the person that the corporation is dealing with knows you are an agent? That is slide 74, and I use Peak Performance Pontoons as a perfect example. When you sign contracts, when you sign letters, when you sign invoices, when you sign emails, you want to make sure it's clear that you are not signing them. You are signing them on behalf of the corporation. So you put the name of the corporation right above where you sign, and you put per in front of where you sign. And underneath the line, in the world according to Peter Holden, this is not absolutely necessary from a liability standpoint, but I think in the world according to Peter Holden, make sure that there's one more indication that you are signing on behalf of the corporation. So you put authorized signatory under there. Are you the authorized signatory for you? No. You're you, okay? So if you put authorized signatory, what you must be saying is I'm authorized to sign for someone or something else. Okay, the word per means on behalf of. So that little bit to the left which says on behalf of, you do not put on the signature line, okay? And I should probably be more obvious in my slides, and maybe I should put in an extra slide next time showing the signature line and then showing afterwards what on behalf of means. Privity of contract, I think, is in the bottom of that screen. I'm just going to take a little closer look here. Oh, no, it just says in the world according to Peter Holden. Okay, privity of contract really means that you can only sue a party to the contract, and you cannot sue the president of the company because they're not a party to that contract. Bingo! There's the limited liability. But you have to do your due diligence, okay? You cannot sign, for example, have a signature line, sign there, and then underneath put per Peak Performance Pontoons Inc., because judges don't like this, okay? They think that you're hiding behind the corporate veil, and you are, okay? And so they look for any way possible to make you liable. I had a client that had a corporation, and they wanted to form another one to do a specific project. And that was the marketing and advertising company that did the limited liability partnership. But they wanted to do this other corporation, and I incorporated the company for them, and I sent them a reporting letter, and in there I explained that they have to sign exactly as slide 74 shows. A couple of years go by, and one of the principals of that company, and I shouldn't use principals because that's the corporation and they're an agency agreement. One of the directors sends me a contract and says, would you please check this over? And I got to the end, and he had signed it with a line, and underneath said per the corporation, because he remembered something about that. Now, Peter told me. And he couldn't find the letter, so he thought, oh, well, that's close enough, okay? Well, the problem with that is if you sign and then underneath it says per the corporation, all that means is you're signing and you're agreeing to be bound by the contract with the corporation. And I called him up and told him that. And he said, but isn't that close enough? And I said, no, close is only good in nuclear war, grenades, and horseshoes. Okay, and you have to be specific because the judge is looking to make you liable. Well, the fiduciary duty is not just, the due diligence is not just signing that way. Section 142 of the BC Business Corporations Act specifically provides for this whole concept of due diligence, and I'm just going to remove my blocker here and read the screen. So I've given you section 142, and it says a director or officer of the company, so that's a director or the president or marketing manager, must act honestly in good faith with a view to the best interests of the company. This is your fiduciary duty. And then it goes on in sub B to say exercise the care, diligence, and skill of a reasonably prudent person that would do in the same circumstances. So what's that mean? Well, it means that due diligence is something that should encompass every aspect of your business. For peak performance pontoons, it's hiring good employees, supervising them. It's making the product, but not just making the product, but testing it for safety. It's honesty in marketing and advertising. It is signing contracts with buyers correctly. It's everything, okay? You have to do your due diligence in order to avail yourself of the due diligence defense. Okay, now we're going to the next slide, and gosh golly gee, I am really quite clever because the next slide is the other advantages of a corporation, and I inserted a slide there to do that, but in fact I've already done it. So let's look at the advantages and disadvantages of the corporation. We talked about the limited liability. That's one of the key ones. The next one is there's a separation between ownership and management. A few years ago, my wife came to me and said, "Can I take $5,000 of our money and buy and sell stocks and see if I can do okay?" And we could afford to lose $5,000. We wouldn't like to lose $5,000, but we could afford. So I said, sure. So she bought some blue chip stocks. She bought shares in the Bank of Nova Scotia, shares in TD Bank, and then she bought some riskier stocks and lost money on the riskier stocks. But she's making money on the bank stock. Well, she owns shares in these two banks. What does my wife know about managing a bank? Like not just a branch, but the whole operation? Nothing. But what she does know is that the board of directors that are there and the officers that are there, the president of Bank of Nova Scotia, etc., they know because they're making, or were before COVID-19, we're making huge profits. So there's a separation of ownership and management. I would love to have 1,000 shares of Microsoft. I don't know. I couldn't program a computer if my life depended on it, but they do. They know how. So I can invest in that company, comfortable that the management is good enough to make a profit. Okay, continued existence, we've already talked about that. Corporations continue on. The shares of the corporation get passed down to heirs and beneficiaries, but the corporation just continues on. It's a real advantage. There's no loyalty or duty of good faith on behalf of the shareholders, and you just have to look at those shares my wife bought in the Bank of Nova Scotia and the TD. Wait, isn't that a conflict of interest? No, it isn't, because all she can do is vote for the board of directors. If she was on the board of directors for the two banks, then we would be laughing because they make a lot of money. But more to the point, if she was on the board of directors of both companies, then that would be a conflict of interest. How do you give the best advice to the TD Bank when you're also working for the Bank of Nova Scotia? And then the last one is possible tax advantages. Okay, I pass the baton to the accountants here because this is well beyond my expertise. I can sort of bumble along and explain. When you when you start a partnership, you have expenses, okay, and those expenses are a tax-deductible expense, so you can reduce your income and save on taxes. In a corporation, all those pre-incorporation expenses are yours, but the corporation is a separate legal entity, so you cannot deduct them. But a corporation does provide you the possibility of splitting income. Okay, if you have a corporation and you're operating it and you have Class A voting shares, you can give your spouse Class B non-voting shares, so they're not involved in the operation of the business. because you'd wind up fighting with your spouse. Just kidding. But you can say dividends, okay, $80,000 worth of dividends. If you give yourself the dividends, it's going to go into your taxable income and bingo, problem. But if you can give dividends to your spouse, then they'll be in a lower income and you can split income and things like that. Okay. And also your corporation is taxed at 50% unless it's a Canadian controlled corporation, okay? So if you're in a partnership and you're making $120,000, you're probably paying about a 50% tax rate, right? Well, your corporation is paying a 50% tax rate unless it's a Canadian controlled corporation, in which case it's taxed at about 22%. So suddenly the money is being taxed at 22%. You pay yourself a dividend. The dividends are taxed at 14%, and suddenly your taxable rate is like 34% instead of 50%. Okay, so you can do things. Talk to an accountant. There's possible tax advantages. Disadvantages, there is the cost, okay, and I should probably have an X beside that. When you're incorporating a private corporation, it's going to be about I haven't been practicing law for a year and a half, but it's probably, I used to do it for about $1,200, okay? That's not huge. I mean, usually people are starting a business, they have no extra income, and they go, oh, $1,200, oh, that's horrendous. But in the actual scheme of things, $1,200 is not too much. And then a shareholders agreement on top of that, because you should have a shareholders agreement, would be about $1,500. So $2,700. Well, let's say the shareholders agreement costs a little more. So $3,000 and you've got yourself a corporation and a shareholders agreement. That's not prohibitive. The cost becomes significant when you try to list on the stock exchange and become a public company. You need a whole bunch of seed capital, and it's going to be somewhere between $500,000 and $600,000. Okay, and so you need promoters and investors and stuff up front, and it gets prohibitive. But for most of us, a private corporation cost is somewhat of a disadvantage because you have something less than that if you're doing a partnership, and even less than if you're doing a sole proprietorship. But compared to a public corporation, insignificant. Regulatory requirements. If you're listed on a stock exchange, you have regulatory requirements up to here. It's like, but if you're a private corporation, when I was a lawyer, I handled about 35 corporations. Well, they would pay me $285 a year plus taxes, and I would keep their company in good standing. That's the regulatory requirements. Okay. I file an annual report with the provincial government, which is not annual financial statements. It's merely a report on who the directors and officers are of the company and is it still operating. And I would prepare a consent resolution of the shareholders and a consent resolution of the directors, and bingo, that's it. And so I would keep them in good standing. There is a term you should know, good standing. What that means is that you are up to date with the filings with the Registrar of Companies. If you are not in good standing and you're getting into a business deal with another company, the lawyer for the other company will do a corporate search and he'll say, whoa, okay, your corporation is not in good standing. The deal's on hold until you repair that. Because if you're not in good standing, your corporation may get struck off the register and no longer exist. I became the registered and record office for a corporation because of that problem for someone. There was a fellow who was an investor and an angel, okay? In other words, what his job was, he would find a business that was really a potential business and say, okay, I'll get you some investors or I'll invest in that. And he did it through his corporation. But because it was only him, he operated out of his house. Well, he moved numerous times. 1 year after incorporation, the Registrar of Companies sends a notice to his address saying it's time for you to file your annual report. He's moved. He gave changes of address to everybody but the Registrar of Companies, because who thinks of that, right? So does not file an annual report that year. Next year, notice goes out, it's returned. Following year, notice goes out, it's returned, and the registrar says, okay, new notice goes out, your corporation is going to be struck off the register. It's going to be dissolved. He doesn't get it. His corporation is struck off the record. He's about to get into a big deal with another business. And the lawyer says, oh, well, the deal is at risk here because you don't have a corporation. He goes, yes, I do. I've had a corporation for years. And the other lawyer said, well, I've checked the registry and you're not there. So he checked the registry and then, called and talked to an officer. And, oh, well, you were struck off the register, last year. Well, so he got referred to me, and I managed to reinstate his corporation. Now, he was lucky because in the meantime, nobody took the name. Otherwise, he would, get reestablished, but he wouldn't have his name. And also, there had been no contingent liabilities or problems in the meantime because he would have been personally liable. Why? Because his corporation did not exist. So every time he signed a document, corporate name per authorized signatory, do this. Take off the corporate name because it doesn't exist. Take off per because you cannot be signing on behalf of something that doesn't exist. And you cannot be an authorized signatory for something that does not exist. What's left? Your name. You become personally liable in that contract. So anyway, we got him reinstated, okay? But you have to keep your company in good standing. Okay, so that's the regulatory requirements. Pardon me. If you have a corporation and it goes insolvent or bankrupt and there's a loss, let's say there's an $80,000 loss, you cannot carry that loss forward or carry it backwards for the purposes of deducting it from income to reduce your taxes. If I'm a sole proprietor and I have an $80,000 loss and I manage to pay off that $80,000, right? I've got this loss. I start a new business and I start making a lot of money. Well, I can use that $80,000 loss because it's my loss, not a corporation loss. It's my loss, and I can deduct it from income I make to reduce my taxes. You have to talk to an accountant because you can take it forward so many years and back so many years to adjust your taxes, okay? All to try to encourage people to invest in business. Okay, so no ability to carry losses forward. Why? Because the loss belongs to the corporation, not me. Okay, so if the corporation goes insolvent and I start a new corporation, I cannot use the loss from that corporation with this corporation because they're separate legal entities. And then the last one is guarantees. This is in a lot of books, okay, a lot of textbooks, and so I have included it in my textbook, and this is the chapter that's on Moodle that you can read about corporations. I've included it because everybody talks about it, but I've included it to point out that it is not a disadvantage. If I am a sole proprietor and I get a bank loan, I'm liable on that bank loan. If I have a corporation and the bank says, okay, we'll lend money to the corporation, but you have to sign a guarantee, I'm liable on the guarantee with the corporation, but I don't have to sign a guarantee as a sole proprietor. Yay, but I'm liable anyway, okay? So having to sign a guarantee is not a disadvantage of a corporation over sole proprietorships and partnerships because you're liable for the debts there, and this is just making you liable for the debts here. Very few businesses ask for personal guarantees. So you deal with suppliers, no guarantees. You deal with your customers, no guarantees. You deal with a bank to get a loan. Well, they've been stung often enough knowing that they lent money to a corporation that went insolvent. They could not pierce the corporate veil to go after the shareholders, directors, or officers. So what they do is they lend money to the corporation and they say, hey, you as the director have to sign a personal guarantee. So that's why there's an X beside it. And there's an X beside regulatory requirements because I don't think that's a really big deal either. All right, now we're getting into a separate slide, and I'm just going to take another look to see how we're doing time-wise here. That's another 36 minutes, so I'm going to take another short break here, and then we'll do this last slide. Sorry, not the last slide, but the slide on getting your estate in order. Okay. All right, we are continuing on, and we are going to be looking at slide 78. We've talked about agency agreements and how that whole concept of agency law provides for protection of directors and officers in corporations. The other aspect of agency agreements is something that you should take into account very early on in your business careers, and even earlier if you start to amass assets, and that's how to get your estate in order. I have a client who, Shane, who runs a business that is making money hand over fist, and it makes the money hand over fist because of him. Now, he has some employees that do the grunt work, but what he does is what brings the income into the business. And I talked to him one day and I said, okay, Shane, what happens if when you retire? And he says, well, the business will be sold and the money will go into my estate and then eventually go to my kids. Or maybe one of my kids will take over the business, but it doesn't look like it right now. And I said, okay, that's good. But what happens if you die? And he went, oh, like, what do you mean? And I said, well, without you running that business, what happens to the income? And he says, it goes, just drops off. And I said, okay, so if you died, then that business becomes of negligible value because it has very few assets. And your estate gets very little. And he went, oh. And I said, so you should have some sort of a succession plan which provides for the continuation of the business after you die so that it can be sold as an ongoing concern. And the same thing with a disability. If, for example, you wound up incapacitated and couldn't do the work, what happens? And he went, oh, yeah, same thing. So I said, okay, we should get your estate in order. And the first thing we did was we drafted a will, a last will and testament for him, which said that his estate should be divided up equally amongst the children, okay? And certain things he wants to go to certain kids. Without that in place, everything in your estate gets sold and the money gets divided up. So if you have specific things that you want to go to specific people, then you have to have a will. My father made a will years ago, and he was old school. And so he had a son, me, and 2 daughters. And he had the family home, a retirement home on Gabriola. And he said, well, the house, the home goes to the eldest son. I mean, that's the way they used to do things in the past. So he drafted this will and said, Peter, you get the house. My 2 daughters will get, whatever's left over, divided up. Well, the house represented most of the wealth of his estate. And that's what he wanted in the will, and there was no getting around it. That's the way he wanted it. So I was drafting the will for him, and I went to my 2 sisters, and I said, okay, look, I don't want to get in a fight with you guys. So what's going to happen is, eventually my father will pass away, and the house will come to me, but we'll sell it and split it 3 ways. His anticipation was in keeping with olden days when the house went to the son and he would live there, and then he would give it to his children, or his eldest son. So anyway, we didn't tell my father that, and so he was happy the way it was done, and he did pass away, and we sold it and divided it up 3 ways. But I could do that because I was the recipient of the house. So anyway, you have a will so that you can say what goes where. If you do not have a will, then the person is not the executor of the estate, he's the administrator, and it's his or her job to sell everything and divide it equally in accordance with the heirs. So if you no will, somebody is an heir. If there is a will, then they're a beneficiary. So the first thing you have to do is have a will. But the will speaks from date of death, okay? Until then, it's just a piece of paper with your signature on it and a couple of witnesses. You can change it and write a new one. You can throw it away. You can do anything you want. But it becomes legally binding when you pass away. But for Shane, because he wanted to have someone operate his business, keep it as an ongoing concern, either after his death or while he was incapacitated, he would provide for in the will that a certain person would receive and operate the business. And then during lifetime, what he did was he had a power of attorney which he gave to one of the managers in the office of his business that knew how to do the work, okay? And said, if anything ever happens to me and I'm incapacitated, you run the business. Then you can either, wait and see if I'm going to recover, or if I'm not, then you can buy the business yourself, or you can arrange for the sale of it, okay? So that was a power of attorney which allowed somebody to do for him something that he was, unable to during his lifetime, and that was for business. Personally, he did not want this manager of the operation to be, paying his hydro and doing his banking and things like that, right? So he had another power of attorney in which he gave a family member the right to be the attorney to do his personal work. The fourth document is called a representation agreement. And this document is designed to provide someone the authority to make medical decisions for you if you cannot do them yourself. Now, these can be fairly dangerous documents in the sense that you're giving somebody the authority and you want to feel relatively comfortable that they know your wishes and that they are going to abide by them, because they can make any decision they want. The blanket agreement that I used to do for my clients, I put in everything, all right? And then you would read it and you'd say, no, I don't like that clause, or, something like that. One of the clauses in the blanket agreement is that if you as the representative think that somebody is become mentally incapacitated, you can have them committed to a mental institution for 3 days psychiatric examination, right? You give somebody, you give your spouse that right under the representation agreement, and you get into this huge argument, and bam, you wind up in a mental institution. So you have to be a little careful what you do. One of the things that you may consider putting in there is if you are incapacitated and you are being kept alive by a respirator. Well, COVID-19, there's something like a 12% recovery rate. If you want to respirator, 12% of the people recover and the rest pass away. So if you're going to pass away, it's going to happen within, a few weeks. Not critical. But what happens if you have a stroke, a massive stroke, and you're on a respirator, and there's, almost 0% chance that you will ever recover? The cost of keeping you on that respirator and artificially alive will be a huge expense to your estate. And unless you have a lot of money or medical that can cover something like that, it becomes a tremendous burden on not only the family members that are traumatized by this, but also because of the cost. Your representative could have the power to pull the plug, all right, which is a consideration. All right, so the representation agreement, that statute came into effect in BC in about 2004 or 2006. Before that, a spouse had no legal right to make medical decisions for their significant other or their spouse without that agreement. And we didn't have a law for that, so you couldn't do it. And that happened when my mother-in-law went into the hospital. My daughter was there with her. It was in the middle of the night, and the mother-in-law was having trouble breathing. They were going to put a tube down her throat, and she was, semi-conscious, and she was, really stressed out. And the administrating doctor said, okay, we have to give her some blood pressure medicine. My daughter was there and said, no, 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 not that medicine. That medicine will kill her. The family doctor knows this, and you have to give her something else. And the doctor turns to my wife and says, who is this woman? Get her out of here. And he was going to give her the blood pressure medicine because he knew better. That's a real danger, okay, because the mother-in-law could not give instructions to the doctor, and the doctor was ignoring the wishes of the daughter because there is no legal right for her to do that. The only reason my mother-in-law survived was we have a really, weird family doctor. She is incredibly weird. She's really good. I like her because I have a lot of sports injuries, and she would always know exactly what it was and exactly what I should do for them. So, but anyway, she's a real strange lady in the sense that this is like 2:30 in the morning, and my wife called her, and she came down to the hospital. Now, what's strange about that? Well, the strange thing is most doctors, family doctors, do not do that because you're at the hospital. You're under the care and guidance of some really, really capable people, usually. And so, and things have to be done immediately. And by the time the family doctor got there, everything would be over. Fortunately, she was close by. She came to the hospital, walked in just before the administrating doctor gave the blood pressure medicine and told him to back off. She was taking over because that medicine would kill the patient. Okay. So, but had my wife had the representation agreement, she would say, no, don't do that. And then the doctor has to listen. Otherwise, it's malpractice. It would be unconsented to medical treatment. All right. Now, how does the doctor know that that person is actually the representative? These representation agreements, what's the likelihood that you're going to have that document in your back pocket? Oh, mom's going to the hospital, and, here's the document. So, no, but you register them with a registry. The doctor can, in 2 seconds, go, okay, yeah, Kathleen, okay, yeah, that's the representative. All right, I have to listen to you. So you should not only have a representation agreement done, but you should register it. And you keep the original in a safety deposit box. You make a copy, and maybe in an emergency, you're thoughtful enough to grab it on the way to the hospital. All right, so those are the 4 documents, legal documents that you can do. The will becomes a legal document on death. The other 3 are legal documents, and then the 5th one is a comfort letter. It is not a legal document at all. I'll make one other comment before I get to that. Power of attorney for business, power of attorney for personal use, representation agreements, express agency agreements. Okay. Express agency agreements because in writing you have expressed your desires for that person to either be your attorney or your representative. The comfort letter is just a letter. All right. It is not a legal document at all, and it does not become a legal document like a will. But I'll give you an example. I had an aunt 3 times removed or whatever in North Vancouver that I never knew about. She didn't even know about me. She passed away. Her son was in Australia and had lived there most of his life. And he whipped into town, called me up and said, Peter, we're a relative. You don't know this. You're my cousin 3 times removed or something. I need you as my lawyer. Come with me. We're going to go look at go over to my mom's house. He said, all right, my mom's passed away. He said, I loved her dearly. She loved me. I live in Australia. We didn't see each other as often as we wished. But even though I love her, I'm involved in a big audit with the corporation that I work for, and I've got to go back. So here, you handle the estate. Do whatever you have to. Bill me. Goodbye. And he leaves. And he goes back to Australia. And I go over to this aunt's house, aunt 3 times removed, that I didn't even know was there, and I use the key, and I go in, and I sit down at her desk, and I go, okay, does she have a will? If she does, I don't see it here. It must be with a bank. I wonder where she banks. I wonder if she banks at a couple of banks. I wonder if she has any investments. Does she have any life insurance? I knew nothing about her. And I didn't charge my billable rate as a lawyer. I charged what an executor would charge under a will, which is, I think, 5% of the value of the estate or whatever. But you know, and I wasn't traumatized by her death because I didn't even know she existed. And yet it was very stressful for me to be going through the personal papers of this person. So I can imagine how it would be if you were the executor under a will and you're one of the family members and you're traumatized by the passing of your mother or you know, brother or sister or whatever, and then having to do all this on top of it. Well, the comfort letter is a letter that the person writes out and says, I have a last will and testament. It's at the Toronto Dominion Bank in a safety deposit box. The key for that is in the drawer of my desk at home. I have life insurance policies with these two companies. I have these shares. The share certificates are in the safety deposit box. I bank with these two institutions, and I have some guaranteed investment certificates with these institutions. And it helps with the estate. And you can also in there do things like I am leaving the gold watch to my son because it is an heirloom that should go to a male. So my two daughters don't get anything, so I'm going to give them $1,000 each just so that they're treated equally. But I didn't want them to think that I loved the son better than them. You can do those kinds of things in the comfort letter. You don't do those in the will. Wills speak from day to death. You're not there to explain what you meant by that. So you do wills that work. Okay, lawyers know what wills work. So you do that. And then you explain things in the comfort letter. So those are the 5 documents that you should do to get your estate in order. And the 3 of them are express agency relationships, which relate to corporations. But having your estate in order is also important if you have a sole proprietorship, partnership, or a corporation, because it will have a succession plan in there. The chapter on corporations ends with a discussion of what you should have in a shareholders agreement, because earlier on, remember I said if you have a partnership, you should have a partnership agreement. If you have a corporation, you should have a shareholder agreement. This is absolutely necessary, and most people don't. And a lot of businesses just make the mistake of, well, we'll incorporate the company, we'll get going, and then we'll sign the shareholder agreement. Seldom if ever happens. Well, my client that had the ad agency sold it and became involved in a cruise ship franchise and was supposed to get a partnership agreement, didn't, and then got bitten on the butt because of that. Well, he shot himself in the foot again because they were operating for a number of years and suddenly they were making money hand over fist. Okay, and they're in very high personal tax brackets. Okay, so the accountant comes along and says, what you should do is you should incorporate so we can do some tax planning and reduce your taxable income payable. And so they say, okay. So they come to me and they say, okay, we're going to incorporate. Is there anything else we should do? And I said, yes, you should have a shareholder agreement. And I drafted one to them and I sent it down to them. And I said, okay, look at this and decide whether or not, it works for you, and then we'll make amendments. They never did. They're far too busy. This is, something you can do later. They never got around to signing the shareholder agreement. So we incorporated a company, and in there was this restriction on the sale of shares. Okay, you put it into the articles of the company. So it was in the articles of the company, which I said we could amend through a shareholders agreement if they wanted to. Well, the articles of the company say that the directors have to agree on the sale of shares, right? So they've been operating and operating and operating. They never signed the shareholders agreement. My client says, I found somebody who wants to buy my shares. I think I'll sell my shares and I'll get out of the company. and then I'll do a little bit of work on the side, selling cruise ship franchises through the operation. They'll get the commission, and I'll make a little bit of money. And so he goes to his partner. What's wrong here? I said, well, he went to his partner, but she is not his partner. If you have a partnership, you're in partnership. You're partners. If you have a corporation, you are not partners. Do not ever refer to yourself as partners. Why? Because if you say, I am a partner with so-and-so, and you get sued and you think, it's okay, we're protected by the corporate veil. No, you won't be, because the person suing thinks you're a partnership. Okay, and then you've incorporated a company for nothing. I'm going to give you two anecdotes because this is really important. One is my all-time favorite client, Ray. I used to make a lot of billings off him because he was always screwing up things. One of the things he did was he sold product to, he was a wholesaler. He sold product to a retailer on 30, 60, 90-day terms. So he sends the product and he's waiting to get paid. Well, 4 months goes by and he hasn't gotten paid, so he calls up. This number is no longer in service. So he goes down to the retail store, big sign in the window, this premises for lease, and there's newspaper put up. So he goes in and he peeks in, there is nothing there. There is no product there. So he tries to find this person and he realizes that the person sold the product, didn't pay him, and is closed down. So he has an address for the person, and so he comes into me and he says, sue this guy. And I said, okay, sue this guy. Is this guy sole proprietorship? Is this guy a corporation? And Ray said, gee, I don't know. So I looked at the business card, did not have the corporate name on. It just said, it was fireplaces. So Velour gas fireplace sales. I looked at the business card, the letterhead, when Ray billed him, he sent an invoice to the person doing business as. There were emails back and forth. We looked at those. There was some correspondence letters. We looked at those. Nothing on any of that indicated that this was a corporate entity. Okay. So we sued the person, and he filed a defense and attached to it a copy of his certificate of incorporation. He said, can't sue me, I have a corporation, limited liability. When we got into court, he was on the stand, and I showed the business card to him and had it as an exhibit. I showed the correspondence exhibit. We took a picture of the premises that had the name but no LTD Anchor Corp. And eventually he was held personally liable because he did not hold himself out as a corporation. So that was one of the scenarios. And now I have momentarily had a loss as to what the other one is. Okay, so there was him. I'm just going to put you on hold until I can think about this because I don't want any blank airtime. All right, now I've remembered what I was going to talk about. So the one scenario, you sue a business. If they do not hold themselves out as a corporation, then obviously you get to sue them personally. And then, why have a corporation? You have to display the corporate name. We took a picture of the premises and it wasn't there. I remember that a fellow by the name of Jim Pike used to come out and talk to our students all the time. He owned the McDonald's on Lonsdale. I don't know if he still does. But I remember McDonald's, but I didn't see a corporate name. So I talked to him about it when he came to be a guest speaker. And he said, walk in the door, and just to the left there's a nice little brushed aluminum plaque there that says Pike Inc. Okay, and so it's Pike Inc. doing business as McDonald's. Okay, the other anecdote was I live in the Sunshine Coast. I travel back and forth by ferry when I'm coming in to teach, which I'm not doing right now thanks to COVID-19. But I was on the ferry, and a business person that I got to know came up and he started talking to me because he wants to get some free legal advice. He was having a dispute in his business with his partner. And so I said, this sounds serious. So it'll be about a $250 retainer for an hour consultation. Why don't you come into my office? And so he said, okay. And he gave me a business card, and it gave his name, partner, underneath. And then at the top, there was a corporation name. And I said, oh, okay, wait, what's going on here? You see, you're a partner, but you have a corporation. He said, oh, yeah. No, I'm a partner in the corporation. And you are not a partner in a corporation. So I told him he'd better give me, a retainer for a little bit more, and we better talk about that as well. So if you do not hold yourself out as a corporation, then you lose this limited liability protection. Okay, that being said, I'm back to the concept of incorporating a company, and I did the shareholders agreement, and I sent it down to my client for the two of them to review, and they didn't. Okay, so finally my client wants to retire and sell his shares. So he introduced the person that was going to buy his shares to his business associate, not partner, and because the corporation was now in place, and he said, I want to retire. And she said, well, sure, go ahead, but you're not going to sell your shares to him. He can invest in the business. He can become a director. He can become an officer. We will expand the business, but you're not selling your shares. And he said, no, I want to sell my shares. And she said, well, you can't. And he said, why not? And I said, because the share sales are restricted. The directors have to agree. There's you and there's me. Two. You want to sell? Yes. I want to sell. Do I want to let you sell? No. Stalemate. And he was on the phone to me, and I said, look, we talked about that, and you were going to look at the shareholders agreement and decide whether you wanted a mechanism to solve a deadlock. You didn't do it. So he eventually just said, oh, okay, and he just left, and he resigned as a director and an officer of the business, and did a little bit of work out of his home to make some money, and retired owning shares, okay, which put her in a bit of a difficult position because she's working there and she has to take the income as salary, and she's in a very high tax bracket, right, except for the tax workings that the accountant was doing. If she declared dividends, he would get half and she would get half, okay, but she just didn't declare dividends, and he ceased being my client, and he's now passed away, and I don't know what happened to the shares in the corporation. So anyway, but you want to make sure that you have a shareholders agreement, and those same clauses that should be in the partnership agreement should be in the shareholder agreement, although the annulment clause is even more important, okay, because let's say you have two shareholders in a corporation. There's me and there's you. I have no spouse, no kids, no close relatives. My parents have passed away. I have a dweeb of a nephew 3 times removed. Okay, that's my only relative. I have no will, and I pass away. My shares will go to my estate, and it will go to my dweeb nephew 3 times removed, whether I like it or not, because I don't have a will, right? So what happens? Well, all right, you've got this key person insurance, and money comes into the corporation, and the dweeb turns up, and you go, okay, here's the money, we're buying your shares. And you go, ball cap backwards, chewing gum, sunglasses. No, dude, I don't think so. Where's my desk, and how much money do I make, and what do we do here? And you go, no, I don't want to be in business with you. And he goes, hey man, I own 50% of the shares. What are you going to do? So you have to have this annulment clause in there that says this contract is shareholders agreement is binding upon the parties hereto, their heirs, the dweeb. If you have a will, the beneficiaries, executors, administrators, representatives, successors, and assigns, right? So then he's bound by that agreement, and in there you have the clause that says the shares must be sold by the estate back to the corporation, and you've got the money from the key person insurance to pay him off and get him out of there, all right? If you do not have that clause, then you wind up with a business associate that you do not want. If he does not like it, he can take you to court. No, he cannot, because you put in a mediation and arbitration clause. He's bound by that because of the annulment clause, and you can have it resolved relatively quickly. All right, let's see. That's corporations. Is there anything else I really wanted to talk about here? No, I think that's it. So that concludes corporations. We now have just 2 more topics to do, and then you will not have my bobbing head anymore. We're going to look at contracts, and then we're going to look at tort law. And just a heads up, I'm going to do a video for the contract section. The tort law, I've already done a video. Okay, it was done for my business law class. Torts, exactly the same. Okay, so I'm going to upload that video for the last topic, which I think is topic 9. I'm just going to run down the list to make sure. Yeah, tort law, chapter 9, or topic 9. It's made for a BADM 107 section 81 class, and in there I refer to a chapter in a textbook, a very old textbook that we no longer use. I will put on eLearn the chapter from my textbook that's designed exactly to cover this topic, and you'll be able to read that textbook chapter while listening to my video, and then afterwards we will have a review session in which I'll flesh out things not covered in that video, and we'll go over a tort problem, which I think is in the lecture materials, but I will check on that, and if it isn't, I will post it on eLearn. Okay, just let me take a quick look here. Yeah, I don't see it there, so I will post it to eLearn. And we'll go over that in class as review for preparation for the final exam. Okay, thank you very much.